It doesn't exist. Therefore, pursuant to all the documents that I've examined in my report and mentioned here today, there's a total of 3 documents that I believe were falsely forged fraudulent documents that were recorded in the Maricopa County Recorder's Office. And therefore, my findings and conclusions are that Aurora Loan Services would not have any valid, lawful chain of title to Ms. Levine's property.
Okay, now Ms. Cantrell, is all this done on your own work, or have you used writings by other people to influence your work?
Well, first of all, I do my own research, and I did my own research. I pulled the documents from the county recorder's office myself, and I checked the verbiage in each and every one of those documents, and I searched all the chain of title from the deed of trust forward and just made these discoveries on my own. Now, Mr. Levine did have a report from Charles J. Horner and Associates, and I'm familiar with his reports. I actually read his report, and I agree with the findings in his report regarding the foreclosure investigation that was done on Mr. Levine's property.
So, are you stating on and for the record, pursuant to your oath, that Mr. Horner, is it? Mr. Horner's documents were correct?
What I found in Mr. Horner's forensic examination of just the foreclosure documents, that portion of his report, I believe it started on page 6 through 9, I read those, his verbiage, and I agree in its entirety with what he put in his report regarding his property.
Did you read the rest of the report?
I did read the whole report.
Do you agree with the rest of it?
I am only going to say that in what my scope of expertise is the chain of title to the property, and that is the portion of Horner's report from page 6 through 9 that I focused on.
Did you see what we've done here? I'm trying to get her out of her expertise so that I can defunct her statements for him. Did she walk out of her expertise?
Not yet. No.
Yeah, I am not an expert on TILA and RESPA violations. I don't need to even say that in court, but I'm just going to say that's not part of my scope of expertise.
Okay.
Chain of title.
All right. I think that concludes the plaintiff's witness testimony. Did you want to cross-examine?
Absolutely, Your Honor.
Okay, please go ahead.
Yes, Ms. Cantrell, you just stated to the court that you've been in this business about 6 years.
I have been employed in the real estate industry for 6 years. I've been a real estate broker, I've been a real estate agent, and I have a certification as a title abstractor. I also have my notary for Arizona as well.
Okay. And
go ahead and say I've been investing in real estate.
I've been investing in real estate since 1997. I actually did have my real estate license in Ohio back when I was 21. I've been in real estate for quite a while, and I've been checking chains of title for years on my own properties. Being that I was an investor, I've had as many as 18 at one time, from what I remember, and I've verified title for my clients as a fiduciary responsibility that I have to my clients to make sure.
Okay, that's very good. Very good.
And Ms. Cantrell, you also state that you are certified title abstractor. And how long have you held that position as, or the certification?
I've received my certification this year, and I have been doing title abstracting for the last 6 years, as I've been engaged in multiple real estate activity, and I actually did a lot of abstracting in 1997 as well.
How many titles have you examined?
Oh goodness, I would have to venture to guess it's well over 200, probably closer to 300. Not every property that I go about attempting to sell or purchase goes through. So I have looked at many chains of title and many title reports in my day. But as far as closed transactions, it's over 200.
I see. And Ms. Cantrell, how many times have you testified in court on the behalf of the plaintiff?
This would be the first time I've testified in court under oath, yes.
I see. Okay. And do you have a contract with, or are you being paid by the plaintiff for your testimony?
I do have a work-for-hire agreement, and I was hired to do the investigation.
Okay, I'm going to overrule that line of questioning. It was already established. I'm not sure what your point is. Of course, she's a paid expert witness. Please move on.
Okay. Well, Your Honor, just the fact that, I mean, even though Ms. Cantrell has been related in this business for...
Okay, for clarification, Mr. Levine,
Yes.
are you arguing with whether or not the documents recorded were false or forged? Or are you trying
No.
to berate the witness?
No, I'm trying to rate the risk. I'm just trying to see if she actually qualifies as an expert, Your Honor.
Okay, that's...
So this is her first time
That's not
giving testimony.
contestable in this hearing. So, since you brought up the subject, and you should be paying attention, Jay, because you need to be objecting to what he's asking her. And that's what I'm trying to get in your head.
All right. Objection, Your Honor. He's only asking her qualifications. He's not disputing her affidavit.
Okay, and what else? Objection, Your Honor. Is he saying that the documents that his client's recording the county recorder are false or aren't false? And does he know whether or not his client committed numerous felonies against the state of Arizona? Get that on the friggin' record.
Okay, Your Honor. I would like to have the defendant admit whether he thinks the documents are false.
Or did he have knowledge?
Or did he have knowledge that the documents are false and forged?
That his client...
That his client's...
Jay, please, come on, buddy. You've got to get this. You've got
Yes,
to.
I'm going to be working on it all week.
What?
I'm going to be working on this all week. I'm
Okay.
going to be over at your house every night.
Lucky me.
How Cindy got it.
I know, I get hammered. I just can't drink when I'm over there.
That's my job.
That's the judge's job.
Okay.
Can I continue my question, Your Honor?
Let me do the really thing. Ask me something about my credibility.
Well, that's getting up to. And Ms. Cantrell, this is your first time testifying in court regarding your findings. I'm not questioning what you're saying. I'm just asking your experience. Aren't you involved in a court case yourself right now, where you are the plaintiff in regard to the same situation?
I would have objected to that. How the hell does he know if it's a first time?
Because I
Right.
said he asked me that question.
But
earlier.
you should object. When this
The
man's asking a
relevance.
question, you object. Right, wrong, or indifferent, you get your objection on, because otherwise you can never fight it.
Yeah.
If he asks a question, you object and think of a reason to friggin' object.
Relevance. What
Okay.
relevance does
Relevant.
whatever
Okay,
I do
objection,
in my
Your Honor.
personal life have
What
to do?
relevance does this have
Yeah,
here?
yeah. The situation is that I'm in a bind about going after her affidavits and her findings, so I'm going to try to attack her personally
And that's
her credibility.
relevance. Is he trying to impeach my witness?
Right. Relevant. Yes, exactly. Okay.
Okay.
Objection,
The other-
Your Honor. This has to go to relevance here. Is he trying to impeach my client, or my material witness here, or is
Impeach
he
the work.
impeach the work, or is he trying to go after her personally?
Okay. The next thing you're going to bring up is that she's
Would that
involved
be
in
badgering?
What?
Would that be badgering?
It could be, not yet, though. We're bordering it. So now you'd come after her about being involved in a group.
Yeah. And Ms. Cantrell, aren't you involved in actually one of the primary supporters or
Objection, Your Honor.
Let him finish.
of a group of here in Phoenix who is an advocacy group fighting and trying to help people in their foreclosures?
Objection, Your Honor. This has nothing to do with her affidavit.
You say I'll
he's
answer.
trying
I'll
to-
answer that, Your Honor.
I
trying to
work
impeach
with a
my
lot
client.
of groups that are notifying the courts of the crimes the defendants are committing. That's all we do.
Your Honor, I work with a lot of groups that are notifying the courts of different crimes that the defendants and other banks are committing. That's what we do.
That's under oath. That's on the record.
Go ahead.
See,
and
let him step. Okay, let him do it. Go ahead.
Which I could do pretty
ask
often.
them about-
play it along.
If you could,
Not
you
anymore.
wouldn't. If you could, you wouldn't.
just ask me anything that about my credit. Just to say which I don't know. You don't
Yeah,
seem
just
very
start.
credible. Just
Go
say
ahead.
that.
And, go ahead and keep trying to impeach her. What I want you guys to know, they're not going to try and impeach the evidence. They can't. And if they can't impeach the evidence, they try and impeach the person. So he's going to come back later and say, Your Honor, that proves everything. We know that if they can't impeach the evidence, they're going to impeach the witness. They haven't even attempted to impeach the evidence. They've tried a dozen times to impeach this witness. They can't. So keep going.
Yeah.
Excuse me, just a second. Just the fact that you allowed this all to continue, if he's trying to impeach her, why can't he object and say, look, here you're trying to discredit my witness.
Because you're allowed to
and yet-
discredit
and
a
yet-
witness.
And yet you're not even credible being before this court with no documentation to prove that you have standing to even be here.
Well, because anybody can impeach a witness. You're allowed to. Because it goes to credibility. So, but just continue on because I want to get you to be able
Ms.
to
Cantrell,
object for the badger.
in your role as an advisor or in your advocacy for the several groups that you help out, are most of them in the same situation in foreclosure, and you're trying to get them to
Objection, he's
try to
leading
help
the
them?
witness.
Objection, Your Honor. He's leading the witness here. He's badgering my client.
Witness, it's not your friggin' client.
He's
What
badgering
the-
he's badgering my client, my witness.
You know, I've really had enough of that. Do you have a problem with her credibility as an expert witness?
Well, a little bit, Your Honor, because this is her first time, her first show right here.
Well, I'll tell you what, for somebody that's her first time on a witness stand, I'm not seeing an issue with her capability on the witness stand. So are you questioning her personally or the outcome of her work? Please inform the court which that is.
It would just be her just her personally, Your Honor.
I'm the same way.
Say, is she single, Your Honor? Ms. Cantrell, you're single.
Your Honor, at this time,
This can't tell. I'll go to my chambers. We're going. One of those in-camera things. Yes.
Your Honor, at
He'll
this
never really do that, though. Protect his witness, right?
If it gets to the point where it's on the record that this is getting a little ridiculous, yeah. 'Cause
Bill McCaffrey puts up with this for about 20 minutes every time he goes to court.
Yeah.
Yeah, they really attack McCaffrey, and he's a well-known expert. You know,
Yeah.
here's somebody who's not known, so I think they're going to jump. I don't have the experience, but I think they jump on her like white on rice.
Oh, yeah. That's
Trying
why
to
what
spread
I
her.
want you to do is just say something and stop. Don't go into this group thing. Just say something. I got something to say. Just
Go ahead.
say, you know, what qualifies you to be an expert? Just stop.
I mean, this is what qualifies you. I mean, you give advice to these groups here.
Just stop. Just what qualifies?
Just
What qualifies you? What do you feel qualifies you as an expert?
Really? You think
Yeah,
that you
really.
got to be an expert
Yeah.
to figure out the type of fraud you guys are committing here? I mean, I could show this to a high school student and they could figure out where the fraudulent documents are and what is fraudulent about this transaction that we're discussing here today. So, I don't think you have to be an expert, but I am under oath. I am sworn to tell the truth, the whole truth, and nothing but the truth. I put forth my affidavit of my findings. To my knowledge, there's not a rebuttal affidavit on the table that's disputing what I have said here, and the only argument is whether or not you like me personally.
Well, and go into how simple the fraud is and how obvious it is.
The fraud is so simple to see. I've spelled it out. I'll be happy to do that for you more thoroughly. Basically, what we have here, I'm just reading from the deed of trust. That's the document of First Magnus, and what it says is that it has to be evidenced by a note signed and dated on October 3rd. What we have is we have a situation here where a notary claims that the deed of trust was signed on the 5th. So, if the deed of trust was signed on the 5th, common sense would tell you that the note was signed on the 5th. So if the note was signed on the 5th, then the deed of trust is not evidenced by a note signed and dated on the 3rd. Therefore, we have a deed of trust that's invalid. A deed of trust pursuant to Carpenter v. Longgood cannot be without the note. Therefore, if the deed of trust is not evidenced by a note signed and dated on the 3rd, then the deed of trust is invalid.
Okay, we've gone over this, and that's it. Just push on the fact that you don't have to be anything special to find this. The fraud is so obvious. Anybody, people that have never done this before, read the documents and see the fraud.
Ms. Cantrell, aren't you being a notary? You're an officer of this court.
No. What
A
else?
notary is a public officer, not an officer of the court. A process server is an officer of the court. Don't confuse those.